Um, Let's start the speech with the model. So the first thing we want to point out is obviously we're going to allow these victims to veto the prosecution of their offender in two key ways. Firstly, they can veto the case being filed as a whole, meaning that they can just choose to not have the case be pursued, or they can veto certain parts of the conviction, like the degree to which the process incarcerates the victim, as well as what kind of punishment or imposition this would put on the victim. Second part of the model, this will be acted concurrently with a variety of other legal mechanisms to provide legal counsel, advice, and discussion. Thirdly, and lastly, a period of 2 weeks to make the decision will be provided as a grace period, and then it can be rescinded within some statute of limitations after that, the time which will probably be decided by some lawyer. That's not me, because I'm not a lawyer. So that's what we think a reasonable implementation of the model will look like. Before I move into my substantive, which will be first explaining why victims should have control over their experience, and secondly, why if this doesn't happen, then victims will seek to undermine the court justice system in other ways. Just some sharp framing to make it clear what we're debating about. So this is not the case in the majority of cases. Most people that experience a violent crime are probably likely to want to pursue the case because violent crime kind of sucks. So there are a variety of edge cases that people do not want to experience or perhaps might want to avoid. So a few examples of this might be like a victim doesn't agree with the case being filed. There are definite examples of a third party calling the police and misunderstanding the situation, which could lead to a legal escalation and potentially taking the case out of your hands, which might actually lead to a violent crime case being filed against someone who wasn't actually like a criminal in that situation. Or it could, for example, be a person that doesn't agree with the punishment that could potentially be levied onto the victim, or it could just be someone that doesn't see the crime as violent, like that particularly famous case of cannibalism, where that guy consented to being cannibalized because it was only his leg. Anyway, so that's just to establish what we think the reasonable range of circumstances in this debate are. This debate mostly hinges on edge cases because this particular part of the policy is for edge cases anyway. So yeah, I'll take a clarification from Go ahead.
Yeah, when you say you have 2 weeks aside and then you can rescind your consent, do you mean like you can rescind your consent to have them prosecuted right up to the point of trial, or rescind your consent to not have them prosecuted, or both?
You can rescind you can rescind the veto. So if after the 2 weeks you choose not to, then you can rescind it anyway, and then have the court proceedings restarted. So first substantive, we believe that victims should have control over their experience in the criminal justice system. Firstly, victims should have the right to determine what is bad for them. We do this already for civil cases, where individuals have a great degree of control over court proceedings and mechanisms for resolution. The principle that undergirds this is that violence is inherently a subjective experience for three structural reasons. Firstly, the experience of pain is subjective. It is purely neurons firing in your brain that connect the neurons in your arm or wherever you got stabbed or something. And as a direct result, it will go through all your biological filters and does not have objective metrics to be measured, because it relates directly to your qualia, which is something that is outside of scientific observation. Secondly, the experience of pain is unique, not just subjective, but also because people experience pain in deeply different ways. Additionally, they cope with pain in different ways and they feel certain things about certain kinds of pain. So something that might be rather grave for someone will be muted for someone else. So realistically speaking, even if something that might be ostensibly painful for you and other people might sympathize with that, if it's not actually painful for you, then there's no reason for you to pursue something that wasn't actually painful for you. Thirdly and lastly is that even if these things aren't true, the resolution should be up to you, because you were the one that experienced that harm. You were the one that experienced that experience of pain. And as a direct result, it should be up to you how to express that resolution of pain, because of the fact that you were the person in that situation in the first place. So preemption, why doesn't this cut the other way? Why can't I stub my toe and have that subjective experience be so immense that I sue the state for having ever created tables in the first place? Firstly, because you only have the right to give up certain proceedings because of the fact that we give you this veto, we don't give you like the other way the right cuts around. But the second thing is, so that's obviously like a bit tautological. The reason why that's the case is you can't initiate harm on someone else from that subjective perspective. You can only lower the degree to which we are willing to prosecute, which is why the principle works in this way. So that's the first sub-reason under the first argument as for why you should have control over your experience. The second sub-point is that there are plenty of edge cases in which the victim's input should take precedent. Again, the instances I mentioned earlier, but also what about instances where you are reasonably sure that this man will get the death penalty? Or what about instances where you're reasonably sure that this man will experience police brutality in prison? Notably, the central conceit of a justice system is that it is just because of the fact that it provides a punishment that is fair for some individuals. We believe individuals ought to be capable of conscientiously disagreeing with that justice system in a way that is fair for them and in a way that does not impose guilt on these individuals. In these instances, not only is the possibility of a wrongful conviction terrible, we also have situations where continuing to pursue the case, even at the behest of the victim, has third-party costs. So, for example, the scandal case I mentioned earlier, or the case where it was a misunderstanding, even if they pursue the case and come to the conclusion that this person that and acquitting this person, there are still massive costs to this person's livelihood. There are massive costs to stigma, the stigmatization that they might experience, as well as just the amount of time wasted in their lives. So we believe that for a lot of these people, and in a lot of these edge cases, the victim's input should take precedent. The third and last subpoint under why victims should take control over their experiences is that in society, pursuing these edge cases might have a lot of harsh consequences. It can be physically, financially, and emotionally draining to spend like half your life at a court proceeding. And moreover, you're forced to recount your experiences of suffering as the accused lawyer berates and scrutinizes every part of that experience if you choose to take part in the court proceeding. And if you don't choose to take part in that court proceeding, not only are you stigmatized for obstructing justice and for not doing your duty to society, but also life is just way worse for you as the court proceedings get extended over time and you get harassed by your neighbors and the friends of the accused. So at the end of this first argument, we prove to you that that justice should be centered around the victim and the experience of the victim. And if a justice system does more damage to the victim than it does to the accused, it is not at all a just system. Second argument, we also believe that according to our framing, if these people really didn't want to have the case in the first place, they are likely to undermine the system in a variety of other ways, not attend court proceedings, delay trials, abuse bureaucratic minutiae. A victim so inclined to not pursue a case that they would be willing to veto it might even go so far as to provide contradictory testimony in order to make the carriage of justice difficult and unwieldy. Why is this relevant in this debate today? The first is that court resources are incredibly limited. So there are obviously there's prosecutorial discretion. The cases are like you have a limited amount of like courts, you have a limited amount of lawyers, and you have a limited amount of court time, which means that every moment your case that is presumably fraudulent because you would have wanted to veto it otherwise, is taking away the ability for someone else to experience justice that may be comparatively more just or comparatively better for them. The second harm that happens here is that you undermine the legitimacy of the court justice system. You add to the statistics that the court justice system is ineffective, and as a result, many other people are less willing to trust in the court justice system. Many other people are less willing to prosecute and report their crimes because they believe broadly in the statistic that they don't get prosecutions and that things don't end up going well. So at the end of the speech, we've done two very, very basic things. Firstly, the intuition, we prove the intuition that any and all punishments meted under the court justice system ought first consult the victim. And secondly, is that if you proceed doing this, it will have way worse consequences on the people we ought to care about the most. For these reasons, affirm. Thanks.
Great. Thank you very much for that speech. I would like to now call upon the leader of the opposition. Here.
Can you hear me?
Yeah, you're audible.
Also, really sorry for having our mic unmuted after the clarification. So sorry about that, RG. Okay, just give me a second. 3, 2, 1. Panel, 3 points in this speech. Firstly, the duty. Secondly, coercion. Thirdly, structural change. Firstly, some responses to the principle from opening government. The rest will be clashed. They say that these experiences are subjective and individualistic towards you. However, happiness is a form of subjectivity. That does not give me the moral right to go and stab someone just because it may make me happy, right? The reason that holds logically here is because of the fact that even though something may be subjectively true, it doesn't mean that you have the moral justification to remove individuals' agency to consent in the future. Because this debate isn't just about these victims, it also should be about future victims. To the extent that that's true, I'll explain why that is more important. But even if the principle is true, note that you have other recourses to fulfill this. Note that you can still do things like go to civil court and not demand, like opt out of civil court and not demand that they pay for your medical fees. The reason that the principle does not apply here is because when that goes to court, it is not the relationship between you and the accused. It is the relationship between you and the state that you've opted into, and about how that individualistically plays out within wider society, because you choose to opt into a justice system when you choose to opt into a state. Look, panel, first point, principle of justice. Look, republic, necessarily, there's four characteristics of a justice system. 1, it incapacitates you in order to prevent you accruing future harms towards victims insofar as it attempts to rehabilitate you, which is the second point. It attempts to rehabilitate you and make you a better version of yourself within that society to protect individuals from the harm, because the reason that you opt out of the state of nature is in order to acquire like things like basic protections from the state. 3, it's often meant to deter other people from acting upon that justice, acting upon those like impulses, and prevent future victims. 4thly, it's retribution in order to prevent society accruing things and society like getting its revenge for the fact those individuals broke those social norms. How is this discharged? One, it is the fact that individual may legitimately fulfilling OG's principle sue them for medical fees or choose not to if they want to. But secondly, it's not fair for them to say that it's fair for you to withdraw that you can't withdraw that consent from that society, specifically because of the fact that you affect wider society, which is how crucially how that plays out. If OG want to engage with that, they can. He will defend it. Second point of substantive coercion. 3 mechanisms under this, trigger warning within that. One, it looks like, and this isn't OG's framing of this is marginal cases. I think this likely happens in a lot of cases and they need to defend that. One, domestic violence cases. The fact when it goes to court because your neighbor reported that it happened means that cops still choose to pursue that case in order to protect you, and of the fact that that means that future victims do not, like that individual doesn't suffer more harm. The reason that even though it may seem okay for you to not want to prosecute that individual is often because it's an irrational emotional pulse. It's the fact you've economic ties to this individual that means you may not want to opt out. It may be that you have a child and you don't want to see their the father or the mother go to prison and you want to preserve that. Those things are often irrational emotional decisions that are not in your best interests, but individuals make them because they perceive them as being good decisions. Secondly, it's gangs. So gangs know that now they're able to do things like coerce individuals in order to avoid themselves being prosecuted. They can knock on your door and threaten you. They can pay you money in order to stop you prosecuting them or receiving the violence. But crucially, what happens here is the fact that those gangs get even more aggressive. So it looks like they're more willing to engage in gang turf wars because they know that they're never likely to be caught or likely to go to jail. The reason that they often don't do this on our side is because even if you choose not to go on the witness stand, it's still the fact that you likely get prosecuted by those police. But given that that they have to defer to that individual, it means that gangs get more powerful and less accountable to that state, and that means that they're able to ravage those areas. I mean, the more individuals are likely to die suffering from things like more drugs being within those areas and individual suffering. Thirdly, it's rich people. So it looks like Harvey Weinstein being able to do things like pay individuals off or threaten them with threaten them with things like not going further in their career because of the fact that now things like sexual harassment also tend to get more aggressive. Similarly for that previous mechanism. Impacts of this: 3. 1. Domestic violence. I think on our side, you're better able to offer these individuals shelter and to escape these things when they know that those individuals are likely to be prosecuted and take them away. The reason that he will defend if they respond to that, but I think it's just that we stop those individuals suffering those harms of those individuals receiving acts of violence. I do not feel the need to explain that further, but I think you should note that there's incredibly deep harm and is traumatic to those individuals that affects their future relationships and their ability to do things like engage in romance that are often very fulfilling. 2, gangs are more aggressive. So I think it looks like them paying them off. Where status quo, they often just divide up markets and protect those people. Thirdly, I think rich people are more likely to be aggressive in those things because they're more likely to engage in those acts of hurting people. CG, if you POI. OG, go quick.
Okay, look, forcing a prosecution will just make them more uncooperative. You haven't proven why a victim unwilling to have the trial in the first place would have a successful conviction.
Okay, here's the thing. Like in a lot of cases, there's still information. There's still a witness that heard those reports or saw those acts, but it's crucial that that individual, right, even if those other cases are out of the debate, it's those crucial cases where those individuals still can get other testimony, but the victim chooses not to do it. Thirdly, why do you have a duty to future victims? Because note that individuals who commit acts of violence are likely to commit them again. Because 1, they believe that they can get away with them because they previously had. 2, there was no ramification or deterrent to stop them. This means that often these individuals, the best thing you can do to those individuals who have suffered the harm is to prevent that harm. But on the comparative, I think it's often that you often individually stop those harms from occurring to future victims, which is an entirely new harm. The best you can do is mitigate it. Third point of substantive, structural reasons. 2 points. 1, I think that regular people often evade convictions. Why? Because I think it's like after 2 years, maybe the fact that you had a broken jaw, that you were in a regular fist fight, but now every time for the next 2 years, because maybe the court's backloaded and it takes time for you to get a trial, it's often the fact that that family of the accused often is like, don't ruin that person's life. They text you, they call you, they often emotionally just try to manipulate you into making that decision. But you've already received the trauma of the first act of violence, but now this other act of violence upon you compounds that harm and makes it harder for you to get over it. But crucially, I just think that those individuals choose to ignore it and fine, stop annoying me, I don't want to get over that trauma, crucially means that that's less likely to happen, that those individuals are more likely to get away with it. Two, I think system seems unjust. So I think you just need to tell a compelling story and the rich people are better able to escape justice. Impacts of this. Three, one, I just think less people are likely to report the crimes insofar as they see other people being emotionally manipulated and they believe that the justice system is likely something that is even more traumatic than it already was. Two, people often feel anxiety because they feel a lot of violent criminals are now on the streets, and their perception of that, even if it's not rational, they believe that that is possible given that this policy, they've no engagement with that in their own life, means that it gets worse. Three, I think it looks like stronger policies look as like strong on crime, individuals voting for that policy and making imprisoned people's lives worse. For all of those reasons, vote OO.
Thank you very much for this speech. I'd like to now invite the Deputy Prime Minister to continue this debate. Hear, hear.
Hello, testing my microphone. Can I be heard properly?
Yeah, we can hear you.
Thank you so much. I prefer my POIs in the chat. I'm going to watch the chat as much as possible. I'm going to start my speech in a few seconds. In 3, 2, 1, and go. Let us not undermine what this debate is about. Opposition relies on a world where they will attempt every single time when there is a potential victim, when there is a potential offender, to continuously file a criminal case every single time and impose the state standards on punishment and prosecution, even if that victim is uncooperative, even if that victim doesn't participate, and even if that case might not even likely be successful, and that a case might actually confirm that this offender is actually not guilty. These cases are immeasurably more complicated than opposition makes them to be. That it is just a violent bad guy and a helpless victim in most cases, when the reality is actually much, much more complex. When we said from opening government that victims can exercise agency even in these coercive situations and even in these helpless situations when they have been offended by these individuals. The principle of the criminal justice system is to be able to reparate these inequalities, and one of these measures and mechanisms is this veto. Before my argument, I'm going to focus on some principled rebuttals to focus on what this debate is about. The first question I want to ask, actually the only broad question of rebuttal that I want to ask is, even if there is a criminal case and there are criminal justifications to want to punish this individual, why should a victim's veto override this consideration? That's the broad question I'm going to answer with a few levels of response. The first response is that notice the previous speaker's implicit standard and the way he which used to compare it against our principle, that the only basis for a criminal prosecution or a criminal case to be filed is for utilitarian purposes. It is for the purpose of having one less offender in society, one less person who is not gonna offend in society, and therefore society's considerations, other people's safety and security deemed by the state's perception on this criminal is more important than any other consideration because it causes like less net harm on these individuals in society. We said in response to this preemptively from Prime Minister that this utilitarian metric pales in comparison to the moral reasoning we brought to you from our first argument, that when we are talking uniquely about violent crimes against these individuals, we are talking about a violation of consent, a violation of safety, a violation of security, of rights that are taken away from an individual that has been uniquely harmed through a particular case of violence that has been put against them. That this violence outweighs those utilitarian considerations because violence is subjective, violence is unique, violence is often disproportionate against these individuals because often people don't just experience it in just one instance, they experience it in a time series, right? They experience it in terms of gaslighting themselves, they experience it in terms of feeling and repeating that memory over and over again. That even if we say other individuals might be more safer in society, we simply don't believe that this standard should be more important than anything else. But the second reason I want to bring is that they give this argument that it's different, right? We have a civil case anyways. Civil damages can be repaired. They can opt to take away the civil damages that are put against them, and therefore they can avail of that. But the criminal case should still be filed. Even if this is the case, I want you to deconstruct this principle a bit more. This individual experience of pain in a subjective manner is not just about a civil offense that is caused against them. And there are a few responses to why this is true. The first is that civil cases often, like criminal cases and the prosecution that happens thereafter, often lead to pain and a disproportionate amount of pain that is also imposed against that offender as well. And that is the symmetric analysis we gave to you from Prime Minister that also causes an inflict of harm against this victim too. That when this person is imposed with a death penalty, when this person is imposed with a trial process, when this person is imposed with life sentence, for example, this victim must have the right to be able to veto these processes, because those things might be disproportionate in their own eyes as well. That is why states often take the advantage of this by saying we should try and maximize the penalty. And society might be well justified in doing so, but victims might be unjustified in believing that this is justified for themselves. And that is why this process of having to gaslight yourself is often very traumatic for many individuals. And we believe putting them through that more harm, believing that it is immoral for them to go through the death penalty, immoral for them to go through more suffering, is something we cannot afford to do. But the second response is this: the principle of civil courts should be extended to criminal cases, particularly for violence, because of the fact of the unique quality of violence that is talked about in this metric, that rights are taken away uniquely, that cannot be measured by states. But to the extent that states measure violence in an objective way, individuals should have the capacity and option to veto and take away what parts of that violence should be taken away and less inflicted upon these offenders. But last is this: if the victim often doesn't decide to participate at all in the trial, which is the biggest utilitarian harm that we even conceded to a Prime Minister, it is going to be much worse at opposition to rely on a criminal justice system where many victims don't even want to participate, when you have lawyers, district attorneys that pressure them to go to the courts, show up to the trial when they don't believe they have any option to go away from this at all, when they are subpoenaed to that court, when they have less and less options. Closing up.
Do you think reparations are justified if they rely on threat to someone else who has an equal moral stake in the situation?
So I think in this instance, the reparations are often measured by these victims. And that is one metric that is considerably done through this veto mechanism. So if you believe that it is justified to punish someone to a life sentence, in many cases, that option will exist because the prosecution and trial will still happen. But it is in the control of these victims to try and mitigate that damage or control it for themselves as to when that it's believed, because they want to participate in that system. The last point of response that I want to do, since this entirely is just about that principle, even if I want to use this utilitarian metric on their world, allowing this veto actually causes more net harm in this system because of the following reasons we brought to you. The first is that it is probably going to lead to more and more inhumane prison conditions if you allow more and more individuals to be prosecuted, more and more recidivism, more less and less chances for rehabilitation, and a more and more tough on crime state that is imposed by this. But the second reason is that more people will show up to trials in our world when they believe they have more control over this process, because they don't believe their hands are just washed off by the state alone. That is a compelling enough reason for us to win in our model. For all these and more, because this debate is about that principle of consent and violence, and it is more so about how individual victims must participate in the system, propose.
Great, thank you very much for that speech. Now I'm going to invite the Deputy Leader of the Opposition to conclude the debate from the opening half. Here.
Cool, can you hear me?
Yeah, I can hear you.
Chair, adjudicators, all the lovely people watching on YouTube back at home, I'm going to do three things in this speech. First of all, I'm going to talk about the unresponded to weighing as to why we're already winning this debate. Then I'm going to delve into clash with OG, then talking about our case and building it up a bit more. Panel, recognize that OG cannot dismiss our metric as utilitarianism. Utilitarianism isn't a principle, therefore it doesn't win. Note that when we weighed out future victims against past victims, we explained to you specifically that all the reasons they care about past oppress victims, because their consent has been breached and because they lack agency, happens to a reasonable extent on both sides of the house. A crime has already occurred to them and they are already somewhat going to be brought into a process of legal systems. They just get a slightly higher opt-out. When we tell you, and no mechanism was responded to, that now people in positions of power over their spouse, or people who were victims of gang and mob crime, or victims of violent crime or sexual offences from rich people, are now more likely to be offended against. This means that more future victims exist on side proposition. At the point at which more future victims exist, then all of their stuff about how we care about rights of victims, how we care about respecting agency, how we care about respecting consent, all of these things which they dismiss as utilitarianism, but are actually rooted in the same principles they care about, they exist to a much higher extent in terms of them being respected on our side. Never respond from OG. OG are already out of this debate. 2 quick lines of response to OG. They say, first of all, reasons why in terms of utility, victims should have input. First of all, because they say, victims should have input if they think someone will get the death penalty or will be unfair. I think this just comes down to a weighing of, do we think the justice system of judges who are democratically legitimate, enforcing the rules of politicians who have been voted in and legislate on these rules, are these individuals more better placed than the average person walking down the street who has no legal background probably to decide if a trial is unfair or not? I think on a way up that falls to us in terms of expertise and democratic legitimacy. Second of all, they say, what if people want to opt out because they are made uncomfortable because of proceedings? First of all, we think largely you can if you want. I mean, you just give a statement to the police and then you give 2 years later maybe a discussion at trial. We don't think it is a massive barrier to your entire life. We also think on both sides of the house, individuals can often be compelled to trial. So this means that if someone is unwilling and disruptive to the trial, they won't actually harm anyone on the north side of the house, because they won't harm the process of the trial, because we have things like contempt of court laws or perjury laws, which means that the trial can still happen. Then they say, well, now you will be pressured on our side of the house. You often get pressured on our side of the house to do things like testify. Panel, you will get pressured a lot more on their side of the house, when first of all, prosecution and police are begging you, hey, you cannot ever drop this case because we need to put this person in jail. Meanwhile, the perpetrator's family is saying, hey, if you keep going with this trial and you don't veto this prosecution, now you are going to be responsible for them dropping out of college, for them losing their job, for their entire life to be destroyed. I think at the point at which they care about victims having reduced pressure on them, if they lose that clash. Talking about the principled clash, Jack explains specifically about how there is a private sphere and how there is a public sphere. At the point in which we think crimes fall distinctly into the public sphere, then you as an individual have no legitimacy to withdraw your consent. What does that mean? It means we agree with all that OG say when they say that the harm done to you by the victim and your relationship with the victim is unique. They have neurons. We think what this means is that OG have proven that a victim has rights to decide the future of the case. They haven't proven that the victim is the only person to have rights to decide what to do with a case. That's why we tell you, when the private relationship between you and the perpetrator, for example, if they break your jaw, you can sue them so that they pay for your medical fees, so that you can repair the relationship that happened to you. So when your neurons fired and that made you feel bad, you can now feel good by getting payment and getting reparations. We think that still exists, and you can still opt out of engaging in that process. But what Jack tells you specifically, very importantly, is that there's also a public element to crime. This means that at the point at which widespread violent crime threatens the stability of a nation, when there's public fear that you are going to be killed because there is a killer still on the streets. Well, not a killer in this case, obviously. If you're dead, you cannot opt out of your consent, but a violent perpetrator. But also we think at the point at which there's public fear in that case, then the state also has a duty, and the state has also been harmed. When they talk about you can withdraw your consent if you are the one being harmed because your neurons fire, your neurons also fire when you have to double lock your doors at night because you think you are going to be harmed. What does this mean? It means Jack tells you specifically that the purpose of a crime is not to repair the relationship between the victim and the perpetrator. It is to incapacitate the perpetrator so they cannot harm society more. It is to rehabilitate them so they can re-enter society. It is to deter other individuals so they know that they cannot interact with crime. It is, fourth of all, to encourage retribution so society feels that they haven't been wronged. What does it mean? It means because a crime is a fundamentally public element, you as a victim cannot consent to denying wider society these duties and these purposes of a criminal trial. At the point in which you are denying society the ability to feel repaired, you are denying an individual the ability to be rehabilitated in a prison, you are denying the deterrent function, the incapacitation function. That is not legitimate. That's why they've lost the principled clash. CG, please engage with me.
I think you've given us a lot of warrants for why this is one of the functions of the legal system. I don't think you've given me comparative reasons for why it should trump the equally important claim of victims' rights. And I honestly don't think anyone in opening half has actually.
First of all, we tell you specifically future victims are way more important than past victims because the margin of harm that can occur to them. Second of all, we tell you specifically that we still protect victims' rights at the point of there are basic protections for them at trial. And second of all, they can still withdraw from your private sphere. When they say, you have an equal claim as a victim to withdrawing your consent. No, you don't. We explained to you how the process of a criminal trial is nothing to do with the relation between the victim and their perpetrator. It is all to do with between a victim and society. That is why on our weighing of an explanation of what a criminal trial is, that is why society has a higher ability to them. We also told you in terms of weighing, if you want to if BACOF want to engage more in a principled analysis, we tell you specifically that or utilitarianism feeds into your principle. At the point which Jack has already proved to you that people in a position of power, status quo, they can be prosecuted because if a husband attacks his wife, you can still have a neighbor call the police, which is enough evidence to get a warrant on them. And once you have that warrant, then you can prosecute that individual even if the wife doesn't opt in. But now on side proposition, the wife can just opt out because they want to care for the child or they are under these patterns of abuse. So this means you get more domestic violence because the husband knows they can keep doing it again and again. The same metric applies towards gang crime. Gangs know that they can now just pay off victims constantly and then they can opt out of that trial. But the status quo, even if they do try and pay off witnesses, because the witness has already given a statement, because there's already been witnesses, this means that you as an individual gang person already has a warrant against you. They already have testimony. So it means you're more likely to go to prison, which means that on the comparative, gangs aren't deterred on side proposition. We also tell you specifically structural reasons how you get more faith in the justice system on side opposition. All of these reasons, never prouder, opposed.
Cool. Thank you very much for that speech. I would like to now invite the member of the government to open the closing half of this debate. Hear, hear.
Opening opposition knows there's a tension in their case because when pressed on it, they ran away from saying that they're defending a utilitarian conception of justice. They know that that doesn't sit well with your fundamental moral instinct. Yet when I asked them very basically to tell you why you should weight one consideration over the other, they rush to a utilitarian analysis about the probabilistic outcome for a future victim that we do not know versus a very real outcome for someone who actually has been affected by a crime. I'm going to do a few things in the speech. Number one, I'm going to break the deadlock on opening half. I'm going to tell you why, yes, we agree that victim rights are important, and yes, we agree that public safety is important. But when weighting the two things in the specific case that we're looking at in this round, one should trump the other on a balance of the moral obligations of the system. This is the most important consideration in the round. Next, I'm going to talk about the trauma and psychological violence that the victim goes through and why that is incredibly important and has been undercovered in this debate. Finally, I'm going to engage with some of the deterrence material from OO. First, when the two are in tension, we say that in these cases, victim rights should trump public safety for three constructive reasons. Number one is that the criminal justice system is given tremendous power, but only because it is constituted by the consent of the people it governs. And OO kind of says this when they say you consented to the system, but their argument was self-referential, right? Because we're having a normative debate about what the bounds of that consent should be and whose consent should matter. And what we say is that any legitimacy to enact a popular conception of public safety or a public good relies on how people define those public goods and whether they consent to the state taking on that role. And ultimately, the people that we're talking about are victims, are the potential victims of crimes. And so in the specific case where the victim has the choice to say that we do not consent to the state's conception of the public good, we think that should trump the theoretical analysis about what they potentially consented to when the Constitution was written hundreds of years ago. Secondarily, we think that generalized conceptions of what makes a person a threat to society are probably weaker than the victim's individual assessment in this case. The key here is that it is not a harm to someone of a weaker moral standard that we're talking about. We're talking about the state's conception of what that harm may be. We think the state's conception is worse than the victim's because given that the victim has a strong belief that someone would not meaningfully threaten others, given that that is the case in which they would most likely actually veto this, they probably have the most specific information and understanding of the individual to make that choice. That is, absent any other criminal activity or record, for example, which is the case in which this would actually happen, this is probably the best determination of public safety risk as well. These people probably have an understanding that they are individuals who are likely to be serial offenders. Either the crime was committed on an accident or it happened under a extreme circumstances that are highly unlikely to be repeated again. And in this case, we think that the more specific and nuanced assessment by the person with the best information trumps a general rule that the state does have to use for efficacy purposes, but probably isn't the most nuanced and specific in this case, even for that purpose. Third and finally, we think that public safety-based determinations tend to be broadly illegitimate on moral grounds. And this is true for two sub-reasons. Sub-reason one is that they often fall along racial and socioeconomic lines. That is, the way in which the public defines who is violent and who deserves what punishment in general is privy to who in the public has power. And we know that juries, prosecutors, lawmakers, and active voters who influence policy all tend to skew towards the dominant group. This influences policing. This influences who actually gets the phone calls for who gets locked up, and this influences sentencing. And so we think that on that ground it's illegitimate. But secondly, we think that most crimes are crimes of circumstance and not of intrinsic evil. That is, people who suffer from addiction, from mental health issues, from poverty, and other forms of suffering tend to give in to their worst impulses, not because they are inherently bad, but because they feel like they have no alternatives, and because suffering brings out the worst in all of us. This is what prompts us to give in to our base level instincts. Now, obviously, we do think that there are cases where people are threats and cannot be rehabilitated. And so as a general, if deeply flawed rule, we're fine with the state acting to address these concerns. But given that the system is inherently flawed and cannot properly, on a moral basis, assess intention or make true moral claims about retributive justice, we think the claim to victims' rights, which is wholly legitimate, should always take precedence if they are in tension. We also think that in the cases where victims veto, it is most likely that they do so because of the two concerns that I stated, because they believe in restorative justice for the individual, because normatively the system should allow for this restoration when the victim calls for it. They may act on concerns related to racial bias or not wanting yet another person from a predominantly Black community to be locked up because they know that the harm to others in their community would often be worse, but that's something that the system simply cannot internalize. So given these three reasons, given the warranting that you had from both opening teams, we broke the deadlock and we gave you the reasons why one moral standing is clearly stronger. Next, on the trauma and psychological violence these people experience. So I want to make it clear here. Many of these experiences, like domestic violence, are incredibly traumatic. Individuals are exposed to violence that causes them to entirely question their being, because often the person who inflicted the harm were incredibly important to their life. It makes them question the most foundational relationships they had, their individual choice to connect with that person. And in these intimate situations, they may even blame themselves for the traumatic pain. So they live with deep psychological pain for the rest of their lives, and recounting it may render them psychologically and physically immobile. The best thing for these individuals is often to move on. For them, recounting the violence lets the oppressor win, because the point of intimate violence is the assertion of power over an individual, and inflicting that psychological pain on yourself means you gave them that power back. Given that this case is so meaningful to the debate, we think the victim probably has to be the most principal observer of intention and harm in these cases. Again, if there were other people who were hurt in the process, you wouldn't be able to veto it because there would be other people who could claim that this was a crime on them as well. So this means that your testimony and provision of evidence and recounting of experience is incredibly material to the case. And what does this mean? Number one, it means you're going to be contacted repeatedly and hounded for information and testimony in many of these cases, which puts the victim in a terrible position. Given that this is a case where it would be traumatic, because this is the case where they would veto it, they are now being told by the state that their failure to recount a potentially traumatic experience puts them at odds with the system and the safety of others. This is a terrible catch-22 situation, and given the power imbalances of the state, they often capitulate, but that puts them in the state of trauma. Second, they will be forced, obviously, to publicly unearth their conception of what happened, which is traumatic in and of itself. But third and finally, they're going to have that experience challenged. Remember that there's a defense that happens in this case. And so people will argue about them with the experience of their deep-seated trauma even being legitimate in the first place. They'll mount a painstaking defense and account of what happened, and you have to question the experience yourself as you live through this. What is the weighing on this argument? We think that trauma destroys people's lives. Their entire sense of self can be broken. An act of violence can break a limb, but breaking somebody's sense of self and their ability to define a good and self-actualize, we think is the most important facet of our existence versus the hypothetical outcome where someone gets hurt. Finally, engaging with people getting paid off. I think firstly that they can still put pressure either not to go to the authorities in the first place or simply not to actually raise the prosecution. But we always think this is worse because people have less of a chance to consent into the kind of pressure they get. That is, if you can go to the legal system, have this person locked up, and then make the decision on your own, you're more likely to make it off of the actual facts of the case than off of the pressure you face in that individual circumstance where the person tells you, do not go to the cops because I'm going to be locked up. So to the extent that this happens in either world, we think it's better when the victim actually gets to consent to the kind of decision they make. We're so proud to propose.
Awesome. Thank you very much for that speech. I'd like to now invite